So our speaker today is Ron Fatoullah. He's been advising New Yorkers about the legal and financial challenges of aging for more than 30 years. He is nationally recognized for his experience in the fields of elder law, trust and estate planning, and Medicaid planning. The firm adheres to the highest form of professional and ethical standards and handles cases involving Medicaid eligibility, estate planning and estate litigation, special needs planning, preparing wills and trusts, probate, and guardianships. In addition to his law practice, Ron Fatoullah is a partner advisor with Advice Period, a leading wealth management firm where he delivers conflict-free, sophisticated planning-based advice to his clients. Ron serves on the executive committee of the Elder Law and Special Needs section of the New York State Bar Association, serves as co-chair of the board of directors of the Long Island chapter of the Alzheimer's Association, and chairs their legal committee, and he also serves on the executive council of AARP in New York. Mr. Fatoullah's distinguished reputation is based on his contributions to the senior citizen community and his 14 inclusions as New York super lawyer and best lawyer. He's a frequent speaker on estate planning and elder law and has contributed numerous articles to the New York Times, Newsdays, the Wall Street Journal, and various online publications. And today, Ron is going to talk a little bit about changes in Medicaid due to the coronavirus pandemic. And Ron, I'll leave it up to you.
All right. Thank you so much, Diana. It's great to be here. Thank you for setting this up. It's just amazing how much has changed in the last month. We thought with the Secure Act, that was going to be it. What a big change, for this year. And that now it's almost like nothing. I mean, so much is going on with the pandemic, with Medicaid, with elder law planning. It's crazy. Everything has been turned upside down. I just want to personally say that I hope that I just know that some of you have dealt with this virus personally. You've had it. I'm glad you recovered and on this phone. Some of you have not recovered. I'm sure all of you know some people that have passed away. I certainly do, unfortunately. And, hopefully together we'll get through this quickly. All right, so let's get going. I'm going to start with some basic things. I'm going to get into more specifics, jump back and forth from the basic to the specifics, because I know so many people here are new to this, although some people here are seasoned. So we're going to go back and forth. So when I sit down with a client, I always tell them that you gotta have your team together. That's the attorney, the financial advisor, the CPA, and sometimes the GCM, the geriatric care manager. The attorney in an elder law situation will look to Medicaid planning, long-term care planning, planning for incapacity, estate planning. We also look at estate tax planning. Those people will not go on Medicaid, not with the current exclusion levels, but that's part of the deal as well. So as people age, they have needs, whether they're wealthy or they're not, they still need to get a plan in place. The financial advisor is very important. We want to make sure that the financial advice that the client is getting will match the legal plan and that the advisor knows what to do. It is so important. For example, with our typical Medicaid Asset Protection Trust, if any part of that principal goes back to the grantor, which is typically, let's say, mom or dad, any of the principal, one penny, the entire corpus of the trust is available for Medicaid. So the financial advisor has to know what the laws are and make sure that everything is managed just right. And how do you get money out? How do you get principal out? Well, that financial advisor has to know the terms of the trust. And that's why my son and I, years ago, joined forces together. I don't do the investment advice, but I do the estate advice, estate planning advice, the elder law advice, to make sure that the financial advice and what happens all meshes together with the legalities. The CPA is in there to do the tax planning, the tax prep, and the GCM if there are going to be some health issues That's very important. So what documents are important in an elder law context? Well, especially now during the pandemic. Well, everybody wants a last will and testament. We see so many people that are going into hospitals, coming out of hospitals, especially now. Hospitals were crowded to begin with, but now they're overcrowded. Everybody, we don't know what the future is going to bring. A friend of mine did pass away last week. He was elderly. But I know somebody else who passed away in his early 50s a couple of weeks ago. This could strike anyone. Everyone should have a last will and testament. Where do your assets go when you pass away? And you want to make sure that it's not just the typical I love you will. You want to make sure that you as the attorney think about what's going to go into that will. Most wills should have a testamentary trust. For example, a client wants to give assets to the grandchildren, but she doesn't want the grandchildren to get the assets all at age 18. Spread it out. There might be a disabled child or a disabled individual who's a beneficiary. Obviously, put that into a special needs trust. There might be a spendthrift child. Child can't hold on to money. Put that in a trust, what we call a spendthrift trust, within the will. That's fine as well. So think about the will. And let's say there are no children. And let's say there's a husband and wife, no children. There's a sick spouse in a nursing home. Do you want to have a will that says all of my assets go to my husband in the nursing home? Of course not. But you may want to think about doing within the will a special needs trust for that spouse. We're going to talk about the right of election issues in Medicaid coming up, but think about the will and how you want it. Okay. Next, the elder care planning power of attorney and statutory gifts rider. Why do I call it that? Because it's not just a form that you're going to download. You're going to put in the modification sections many different provisions, and you're going to have a statutory gifts rider so we know that we can have the family plan at the last minute. Even if we did all the planning in advance, at the last minute, we may want to tweak something. Maybe something will happen and we want to revoke that or terminate that trust that we created. Even the irrevocable trust under 7-1.9 of the EPTL, we may want to revoke it, tweak it, amend it, or create another trust. Well, expand that power of attorney so that we could do it, so we could jockey around the assets with the statutory gifts rider. Otherwise, we'd be stuck with a max of transferring $500 per year, and that's nothing. We won't be able to do any planning with that. So make sure clients have a power of attorney, but not just the power, not just the statutory gifts rider. Expand it to include Medicaid provisions like an intent to return home, right to disclaim assets. Just do it up. We might add 30, 40 extra provisions to that power of attorney, depending on the client's situation. You want to make sure that you have it. I always look at it when I look out the window. Make sure that that planning window of opportunity doesn't shut. When the client does not have capacity and doesn't understand the nature and consequences of signing that power of attorney, you can't sign it anymore. Too late. We're going to have to go into court for a guardianship for that individual. Don't let it get to that point. So power of attorney is important. Statutory gifts rider is important, but you need to expand it, make it a very broad power so it has teeth, and we could do planning at the very last minute, or hopefully way before the very last minute. But we could do the planning along the way, whether or not there's incapacity. Healthcare proxy is very simple. The client won't need much guidance with that, or you may not need much guidance with that. Healthcare proxy, you can download and use that form, and it is a very viable form. You can download it on the DOH, Department of Health website. The difference, there are many differences between the healthcare proxy and the power of attorney, a couple of which are, once you sign the healthcare proxy, it's valid, but it doesn't come into effect until you can't make your own healthcare decisions. On the power of attorney, it's not a springing power of attorney when you sign the standard power of attorney. That power of attorney is good right then and there when the principal signs it and the agent signs it. So that's fine. So many of my clients say, well, you know, we have agents and successor agents. Do all of them have to sign it right away? No. As long as you, the principal, signs that power of attorney, can't be used until the agent signs it. But they could sign it later on, even when the principal becomes incapacitated. So healthcare proxy is only good, has the teeth, and only will be used once the individual can't make their own healthcare decisions. Power of attorney is good right now. So let's say this pandemic is in the past tense. Someone takes a trip around the world. It's very hard to get back to New York, and calls on a cell phone and says, hey, Josh, my son, please handle this at the bank. Josh has that power of attorney. He can do that, no worries. A living will is a good document to have. It sets forth in writing what the individual's healthcare wishes are, and it's another way to communicate to the agent on that healthcare proxy, the proxy, as to what the individual's wishes are. If it's a hard decision to make, I think a living will is very good. So an individual might say, well, the agent on my healthcare proxy, or some people say my proxy, is my son Josh, and my successor is my son Mike, and those are my two kids. And that's great. They're going to make my decisions. Well, how are they going to know what my decisions are? I've told them what my decisions are. They know what my decisions are because I spent a lot of time talking about it, but I also have a living will. And that living will should not be a part of the healthcare proxy. But that living will, as a standalone document, is a direction to them. Because I, for one, don't want to be kept alive artificially if there's no chance of recovery. But someone else might want to be kept alive. So that's where the living will comes into play. And I think it's important, absolutely needed, but it's a good adjunct to the documents and a direction to the agent or proxy on the healthcare proxy. Now, the last item that I have here, and last but not least, most individuals, as we do elder law planning and estate planning, most individuals would benefit from a living trust. And I assume you guys know all about living trust, at least some of the basics, because we all took T&E, and my professor was Professor Wang, the father, Professor Wang actually, the father of the computer associates individual. And he was terrific. He was a terrific guy, and I learned a lot, and I remember a lot. But a trust is basically an agreement to create an entity that will hold assets, and that trust agreement specifies how those assets are to be used. When does a trust hold them? What happens to the income? What happens to the principal? In what order? All of the rules are set forth within that trust agreement. The trust could either be a testamentary trust, a trust within a will, or we could have a living trust, which is a revocable living trust, or an irrevocable living trust. Most of the trusts we do for Medicaid planning are irrevocable living trusts. Okay, now, how are we going to get these documents signed during this pandemic? Well, it's a good thing that the governor signed many executive orders, but 2 that involve signing of documents virtually. Thank God. And what foresight this was. And if I had my druthers, I'd like to see this going forward for a lot of my clients that find it difficult to come to my office, or who are alone and won't have witnesses. So we can actually provide witnesses. So let me go through this. And towards the end of these slides will be the 2 executive orders, 202-7, which we have here, and 202-14, dot 14, which I'm going to talk about next, which is also at the end of these slides. So the first one spoke about virtual notarization. So let's go over that. It's pretty simple. It's very straightforward, although there are a lot of questions out there about how we do it, how other people do it, and you just have to do the best that you can. But let's go over the executive order. At least we have this. These are good until May 7th. Today is May 5th. We only have 2 days to go. I cannot imagine that the governor will not extend this. I have no doubt that he will, but he hasn't done it yet. So keeping my fingers crossed that this will happen. And I personally, again, would like to see a legislative fix so that we have the ability to notarize and witness virtually, even if it means signing an original document later on. Because how many times have all of us gone to a hospital? We wouldn't do it now during this pandemic, but gone to a hospital where a client is not doing well, client might die. Certainly don't want to do this. We'd love to do this way in advance, but sometimes you just don't get the opportunity to do it, or the client just doesn't plan. So we go to a hospital to do this, but now during the pandemic, we're not going to do it. Or if it's not safe in the future, who wants to go to a hospital after what we see now? Hopefully we can get to use this virtual notarization and virtual witnessing. So let's go over 202.7. That's the executive order. It's good until May 7th. It'll likely be extended, keeping my fingers crossed, but that's what I hear from Albany. So number 1, you have to have a live audio video conferencing. So it's a direct communication. Can't be pre-recorded, nothing afterward. It's live, like Zoom, like FaceTime, and there's so many others, like Blue Jeans, etc. So we're all getting pretty proficient in these audio-visual programs out there. There are so many. It could just be the client looking at their iPhone and doing FaceTime, and that's okay. Number 2, the individual who's signing the document has to be known to the notary, or the individual has to show photo ID. So have the individual, we do this in all our cases, have the individual show the photo ID license, for example, and then take a screenshot of that photo ID, or take your phone out and take a picture of that and make sure that you have it for your records. It's just good practice because you never know. The individual for notarization must affirmatively state that he or she is within the state of New York. Then the person has to electronically transmit a legible copy of the signed document to the notary on the same day it was signed, and the full document has to be sent for the virtual notarization. Not so for the witnessing, just the signature pages for the witnessing. Okay. And the last bullet point, the notary then could notarize the transmitted copy that he or she just got. So I get this back, see the client sign it, and get the full document back. So here I have the full document. I notarize that document. And then I can, send that back to the client. by mail back to his or her home. And that client could send everything back to my office or my home now. Who knows how long this craziness is going to last. I'm predicting maybe another month for us here downstate. But then we could get the document with the original signature and re-notarize that original document. And that's typically the way we're doing it. You could just keep this in counterpart, and I think that's fine as well. But a lot of clients want to see something a bit cleaner than that. And I know some individuals are just basically, they're just redoing this. The goal is to have this in counterparts. They're redoing it once things go back to normal, if they ever go back to normal, or there's some sort of new abnormal, as I heard someone say this morning. Okay, let's move to Executive Order 202.14. This is where an individual is looking for not notarization, looking for witnessing services. Sorry about that typo. And again, if you don't know the individual and there's a witness, then you want to get that photo ID. You definitely, it's good practice, take a photo of it, take a screenshot, and just keep it for your file. Has to be also direct interaction with a live video conferencing. The witnesses have to receive a legible copy of the signature page that could be sent and received by electronic means. And here it says, or other means. What they meant was it could be messengered back, etc. But it could be done electronically, but it has to be done on the same day. Okay, so that also, sorry about that interruption. Okay. The witnesses then sign the transmitted copy, or the original if it's given back to them, and then can transmit back the copy that was done. The witnesses may sign the original. Now look at this wording. Not should or must, may sign the original signature page or that original document within 30 days of the execution. Look, guys, may, just treat it as must. Just do it. Get it done, and things will be good. But it does say may, and you'll see that towards the end of the slides. And then the witness could repeat doing this with the original signature page, no issues. So it's a bit cumbersome, but it does make things easier for the client, that's for sure. Okay, there are so many changes now with Medicaid. I can't believe it. I didn't think that this was going to happen just now when so many people are going to be needing Medicaid because of this virus. And this virus has hit so many of my clients. So many of my clients have passed away. It's been awful, and so many of them are sick. I know so many of them, and my heart is breaking. Who would have believed that the Medicaid program for home care would have been drastically cut at this point in time? The effective date is out there till, it's not at least until October 1, but who would have thought that this was going to happen now, but it did. So this is what we're dealing with. So let's step back. How do we pay for long-term care? Number one, private pay. But if the individual could pay privately, and this is pretty expensive, the average cost of home care, let's say per month, is maybe $8,000. We have some clients spending $15,000. For nursing home care, the average cost, for the, in the tri-state area, New York, Long Island, New York City, Long Island, Westchester, etc., I would say is about $16,000 a month. It's crazy. So if your client could privately pay, maybe you don't do Medicaid planning, maybe you're doing estate tax planning, and that's important planning to do as well. But if you have the money, you don't need Medicaid. Medicare does not pay for long-term care. Long-term care insurance is good, but a couple of things with long-term care insurance. Number one, most clients simply don't have the insurance. And number two, the insurance companies have been raising rates constantly. I have long-term care insurance, and my rate has more than doubled at this point in time if I wanted the same coverage. And I did want the same coverage. I had pretty cheap, it's pretty cheap to begin with, but they more than doubled it. And I had 2 increases. Not everyone could afford the increase. So you could have a senior who's been paying into this long-term care insurance for years, only to have the insurance company raise rates, and they're stuck with the option to either water down their insurance or to just let it lapse, which is what I think these companies want. But, look, they're increasing the insurance because they don't have enough in reserve. Veteran benefits have also changed. We've all heard about that great aid and attendance program. Absolutely terrific. It was so easy. There was no look back. You could have transferred or gifted assets out, and there was no look back for it. October 18th of 2018, a year and a half ago, we got a 3-year look back for gifts or transfers with a potential waiting period of 5 years. So veterans benefits have been watered down. And we're going to now talk about Medicaid, because Medicaid is the payer of last resort. You can't pay for it privately. Medicare won't do it. And if you don't have long-term care insurance, you certainly can't buy it when you have any sign of dementia, Alzheimer's. My mother had severe osteoporosis and she couldn't get it. So you have to look to the Medicaid program. And please be aware, the spouse is liable. If you say, I do, spouse is liable for the long-term needs, healthcare needs of the spouse, and even the amounts paid for by Medicaid. In many instances, Medicaid may want to step into the shoes of the sick spouse and go after the well spouse for support. Okay, so when we talk about advanced planning, it's important for the individual, and it's also important for the spouse as well. Okay, so next I want to talk about planning for the Medicaid look-back period. Who would have thought a month ago? Who would have thought, well, a little bit more than a month ago, 5 weeks ago, who would have thought that there was really going to be a look-back period for home care? Yes, it was in the governor's budget for years, maybe decades. It was in there all the time. But nobody thought they would actually do it. But they did it during the pandemic. So we have a new, for home care, new 30-month look back. What does that mean? Well, many clients say, Ron, I won't plan now. I'll come and see you. We'll plan later on. I know there's no look back. I could just transfer assets away and I'll go on Medicaid home care. I'm never going to put my husband in a nursing home. I'm never going to put my mother in a nursing home. So it doesn't matter. We'll plan later on. Well, ladies and gentlemen, you can't plan later on. You have to do the planning now. We have to plan in advance because of this new look back. The rules have been turned upside down, turned on its head. We now have these new transfer penalties. I'm going to go over that with you. Going to talk about exempt transfers, going to talk about non-exempt transfers. Those are gifts that create waiting periods. And we're going to get into all of this. And I'm going to talk about so many other changes to the Medicaid program that will require great advocacy by the elder law attorney. So I'm rolling up my sleeves. I love a good challenge, and I'm gearing up for this. But I really wish it wasn't like this. I really do. It's complicated. I'm going to go through some of these things. Then I'm going to talk about planning for the home. And I know a lot of you, this is judicial title, they're amazing. A lot of you are real estate attorneys. You just definitely want to protect the home in the right way. Typically, a life estate is not the best way to do it, but a lot of real estate attorneys just do that because it's easier. Do it the right way. And you can't wait. You want to transfer that home, typically, not always. You want to transfer that home into the trust. You want to start that look back going as soon as you can. And by the way, you know, I'm sure all of you know, and if you don't, you're going to hear it now. There's a 5-year or a 60-month look back for Medicaid nursing home care. Medicaid would look back 60 months of 5 years to see what assets were gifted by the applicant, and if there's a spouse, also by the spouse. Now, how the heck did we get 30 months of a look back for home care? Well, this is where the legislature and the governor just played Solomon. We didn't want the look back. Most didn't want the look back, but there's big deficits. There were huge deficits before this virus even started. And so what they did was they just played Solomon. They cut the baby in half, and instead of a 60-month look back, which is what we still have for nursing home care, there's a 30-month look back for home care. So everyone, in my opinion, starting at age 60, must have a plan in place to pay for long-term care. Okay, so I want to give you now the code word. We're midway through the talk. The code word is Medicaid, M-E-D-I-C-A-I-D. And just to make sure you're listening, we're going to add an E, doesn't have an E when you spell it out, Medicaid with an E at the end for the code word, because I want to make sure you guys are listening. So that's the code word, Medicaid with an E at the end, M-E-D-I-C-A-I-D, add an E. Okay, that's the code word. Okay, so let's do an overview of the Medicaid Asset and Income program. Hang on. Oh, and I'm seeing good. I see that we have some questions coming, and that's good. I'm going to try to leave some time for the questions, but I have so much material to go over, and you're going to see why. And so we're going to take questions at the end. So in New York, the Medicaid applicant can keep, in 2020, $15,750 plus exempt resources or assets, such as retirement accounts in payout status. The home is exempt in certain circumstances. We'll get to that. We can have an irrevocable pre-need agreement, you know, for burial and funeral expenses, reparations, payments by Germany or Austria or the claims tribunal as a result of Nazi persecutions. That's exempt as well. So you have a class of assets that you could keep that are exempt. Actually, I brought the case that started the ball rolling on creating the exemption for retirement accounts. I brought that in Queens about 15 years ago. But after that case, retirement accounts, all retirement accounts in payout status are exempt. So if you're on Medicaid, you have to, in order for it to be exempt, it's the only way I could have argued this to HRA, Human Resource Administration, because that was a Queens case at the time, only way that I was able to argue that when I did. So they're exempt, but you need to take your distributions so that the retirement accounts will continue to be exempt. Now you might say, aha, we have the CARES Act, and in 2020, you don't have to take your RMDs or required minimum distributions. So, we don't have to do that for Medicaid, right? Wrong. Still, the Medicaid rules are the Medicaid rules. In order for those retirement accounts to be exempt, you have to take your distributions. You don't have to for IRS purposes in 2020 under the CARES Act, but you have to do it for Medicaid. So please be very careful. Right now, that well spouse could keep $74,820, almost $75,000, going up to $128,640. For nursing home applicants, that applicant could keep $50 of a personal needs allowance of income a month, with a well spouse, if there's a spouse, could keep $3,216. That's called the MIMNA, or the monthly minimum maintenance needs allowance. Boy, I see so many, a lot of people on the chat. Okay, well, we'll get to that soon. All right. Now, for home care, the individual that's applying can keep $895 of income a month. That is not enough to pay for expenses at home anywhere in New York State. So we have the concept of a pooled income trust, which I'm going to get to a little bit later, which could preserve the surplus income. There is a question as to whether or not we could use this the income trust later on after October 1. We're going to get to that pretty soon. All right. Now, let's continue this overview of the income and asset requirements for Medicaid. Okay, a spouse can sign a spousal refusal. In the budget that the governor signed, they were going to eliminate spousal refusals in a home care setting, but they never did. So a planning opportunity might be the right planning opportunity, depending on the case, could be to transfer assets to that well spouse, because that's an exempt transfer, and then have that spouse sign a spousal refusal. But once that spouse signs a spousal refusal, Medicaid, DSS, Department of Social Services, or in New York City, it's HRA, could step into the shoes of the sick spouse and even go after the well spouse for support and recovery. Be careful, they could do that. So you want to do planning. Don't just, that could be an option, but it may not be the right option. There are many different ways to skin a cat. Now, when does that what does that 5-year look back apply to? Well, 5-year look back applies to nursing home Medicaid only. Right now, currently, there is no look back and no penalty periods if assets are transferred for home care. What does this tell everyone? If there's someone on the border of needing care or not, and you say, oh, I'll apply for Medicaid home care when I need more hours. Right now, I only need 4 or 5 hours a day. Don't wait. Get the application in now. Get it in now. Better to have a little lead time, but whatever you do, make sure that you submit it prior to October 1, 2020. And all applications submitted on or after October 1, 2020 would be subject to that look back. Okay, so I'm on slide 10. I have about 20 minutes to go, and I have so much to talk about, and it's interesting. So as I said, New York State proposed eliminating spousal refusals, but it's still in there. You might have heard that they were going to reduce that community spouse allowance to about $25,000. They're still keeping it at that higher level, $74,820, even after October 1. Again, the applicant can only have the $15,750, $895 per month is that income. Don't forget about that pooled income trust. So the individual with that extra income, or we call surplus income a month, that could go into the pooled income trust and then be used by that trust for a whole bunch of different items, which we'll get to in a few minutes. We are going to be talking about that 5-year look back very soon. Planning now is more essential than it's ever been. So let's talk about this Medicaid penalty period that we have now, and will have for home care as well after October 1. So if assets were gifted, when we talk about transfers in my world, elder law, talk about transfers, we're talking about uncompensated transfers, transfers that are gifts, not transfers that you get something back for, transfers that are compensated. So when we talk about transfers, we're talking about gifts. Strangely enough, the rule for Medicaid home care in calculating the waiting period, that denominator is the same. So New York City is $12,844 on Long Island. It's $13,407. Northern Westchester, it's $12,805. So I'm going to use $13,000. That's pretty easy. So if within the last 5 years, someone transferred, the applicant transferred, or the spouse, if they're married, gifted $13,000, there'll be a 1-month wait before Medicaid will pay for the nursing home care. Or after October 1, there'll be a 1-month wait before Medicaid will pay for the home care. But as strange as it is, the law was written so that we're using the same denominator, which is the nursing home regional rate, as to figure out what the cost, that's the cost of 1 month in a nursing home, but we're using that for the home care calculations. And that's the way it is now. I could almost bet that they're going to reduce that to a lower number in the future. So they likely will do that with a legislative tweak, I believe, but we'll see. But right now, that's the denominator. So if there's only 13,000 gifted in within the last 60 months or 30 months come October 1, there would be a 1-month wait. If there's 26,000 gifted, a 2-month wait. And if there's 130,000 gifted, a 10-month wait. If a home was gifted, you get an appraisal on the home, divide that by, if you're in New York City, 12,844. If you're in Westchester, divide that by 12,805. You'll get a number. That's how long you have to wait. And you could even be waiting longer than the look back. Be careful. So for example, if within that look back, let's say it's a 5-year look back we're dealing with now, somebody transferred $1 million, you apply for Medicaid and they look back and that gift was within that 5 years, they're going to see that gift and say, you have to wait a much longer period than 5 years. So be careful when you apply. The when is very, very important. The next slide shows all of the regional rates in New York State. And we went over them. You're going to have the slides so you can look at that later. We have exempt transfers, gifts that could be made, and Medicaid will say, okay, we see that you made these gifts, but we're not going to penalize you. We won't make you wait for your care. And these gifts, these exempt transfers, would be transfers to a well spouse or a spouse, but don't forget about the spousal suits, transfers to a blind or disabled child, and it's good for home care and nursing home care, transfers made exclusively for a purpose other than to qualify for Medicaid. It's hard to come by. Got to look at the fair hearing decisions, but that's very important. If you buy something and it's compensated and you're getting fair market value, that's not a gift and you won't be penalized. In the same way, if transfers that were made are returned, it'll undo the penalty period. But returning means that the individual pays, for example, mom back, or pays from mom's nursing home care. So you got to be very careful. There are some other exempt transfers. So for example, assets used to purchase a certain type of annuity. Even a life estate is a planning tool that we use quite often. A DRA compliant promissory note is a strategy we've used. In my last lecture to you guys, we went into a lot more depth with that, but today we have so many new things. Now we have exempt transfers of the home, and many of you are real estate attorneys, so can we do this for home care? We know we could do this for nursing home care, and we know that transfers of the home to the spouse are exempt. Well, that's good. Transfer of the home to a disabled child or a blind child is going to be exempt. But let's look at one of the exceptions, the exempt transfers of the home to an adult caregiver child. We use this a few times a week. We use this all the time. And this is what the law says. A transfer to an adult caregiver child who resided in the home for at least 2 years prior to institutionalization, and who is a caregiver, basically, will be an exempt transfer. But look at it. The law says 2 years prior to institutionalization, but for home care, there is no institutionalization. So will this work? The jury is still out. I do believe that this will work, but we don't know. We just don't know. We do have another exempt transfer. That's to a sibling who's living in the home for at least 1 year prior to institutionalization. We could use that for nursing home care. I would say likely for home care, but the jury is still out. Be careful. Medicaid doesn't want you to have too much in the way of assets, and they say you have too much equity in your home if your equity value exceeds $893,000. Not much when a studio apartment in Manhattan could cost you $893,000, or at least before this COVID situation. But that equity limitation does not apply if there's a spouse, minor, blind, or disabled child living in the home. There are lots of practical implications that are quite negative with the use of these exempt transfers. If you transfer assets to a disabled child, what if they're on benefits? Well, we have to do a cost-benefit analysis, and we just have to do planning for the child as well, if it makes sense to do. Transfers assets to, let's say, to a disabled child. Well, let's say mom has 2 other children who are not disabled, but she wants to go on Medicaid right away and gives everything to that disabled child. Then later on, that disabled child doesn't share, and there can't be an agreement to have them share because that's Medicaid fraud. You're not really just giving to the disabled child then. So then what? These issues crop up. They don't crop up when we do the planning, but I've seen it crop up when, some other attorneys actually just do that, and then we have issues. So you want to make sure that you really do the planning right. So oftentimes we're asked to do a family agreement when we do these exempt transfers, but Medicaid has come out and has clearly said that these are, this is Medicaid fraud, and they will not abide by those family agreements, and they would say that that asset did not go solely to that disabled child. Since I don't have that much time, just know that if assets were gifted, let's say to the children, and you can't get those assets back, and you try, and Medicaid sometimes even wants you to go after those assets, even maybe a lawsuit, you can't get those assets back. We do have undue hardship, which we could use if we have to. It's hard to get, but we've gotten it many times, but it's hard to get. So, which community-based services with the look-back rules apply to? Basically, everything that you're thinking of. It's personal care services like a home health attendant, the consumer-directed program where you pick out your own attendant. It could be a child who doesn't live with you. Home care services, skilled nursing, private duty nursing, the out beds, the assisted living program beds funded by Medicaid. And look at this, The New York State Department of Health can, in the future, it's written in, even designate other services which will be affected by the look back. So it's kind of open-ended, so who knows what's coming down the pike. Okay, so what are the effective date of these changes? For applications submitted on or after October 1, 2020 for home care, and we've always had a look back for Medicaid in a nursing home. But the crazy thing is, the look back starts. When do you start to look back? In a nursing home situation, when you're in the nursing home, you've applied for benefits, and your assets are under the Medicaid level, and you've had these gifts. So then they look back and they penalize you for these gifts. But you have to be in the nursing home. So they didn't write the law right for home care. They say that, the 30-month look backs begins when you're receiving the care. But you can't be receiving the care because you're applying for the care that you need. So they're going to have to tweak the law. But this is what we're dealing with. This was a rush job. It was a compromise. It was a Solomon deal. They split the baby in half. And this is what we're dealing with. Now, very importantly, pooled income trust. When a client can't make it on $895 of income a month, then and plus the cost of healthcare premiums, let's say Medigap premiums, the surplus, the extra, will go into a pooled income trust, which is pooled with many other grantors, many other individuals, and that subtrust is drawn down on a monthly basis to pay for things such as, look on this slide, rent or mortgage, utilities, etc. Credit cards. Give a credit card to daughter. It's your credit card, so she has it and she spends it. You may have to prove it, but it's in one place and it's pretty easy. You could get out of that pooled trust upon death, admission to a nursing home, or if you don't fund the pooled trust, etc. But the jury is out whether or not these pooled trusts could be used after October 1, but it likely would be. Now, why is there an issue? It is because the transfer of an asset creates the penalty period, but also, this was changed years ago, the transfer of income also creates a penalty period. So a transfer of income to that pooled trust is a transfer, but you remember the exception, if it's a compensated transfer. So as long as those monies are drawn down on a monthly basis and used, then it's compensated. And then we should be able to use these pooled income trusts. So we're going to have to really proactively figure out how much money goes into that pooled trust on a monthly basis so we make sure all of it is compensated so there are no transfers. How crazy is this? Maybe we're going to get some guidance down the road, but my life has never been made more complicated, but I love a challenge, and here it is. I'm going to try to rush. I'm going to try to finish by 2 o'clock. I know that's the hour. And we have a new assessment tool. Believe it or not, they're making things much more difficult. They're eliminating, as of October 1, housekeeping services for Medicaid. There's a new requirement that you have activities of daily living. I'm rushing through these a little bit, but you need assistance with 3 activities of daily living with physical maneuvering. And if you have dementia, 2 activities of daily living without the physical maneuvering. And at least, you see number 4 there, that limited assistance? Number 4 down is what you're going to need the assistance with. So, wow, we never had this before. So we, as the elder law attorney, are going to have to, not just submitting an application, this is not easy. Everyone is going to need us. If you're an elder law attorney, everyone is going to need you too, because there's going to be a lot of advocacy that we're going to have to do every time we do this. We also, on top of all of this, have a new standardized task-based assessment tool that's going to be effective in about a year from now. So we'll see how that works out. That could be all right. And now, it used to be where the individual's physician would actually get involved. Now it's, it's not there. There's going to be a physician that's appointed by or approved by the Department of Health in New York State. And we're going to have an independent assessor now that's going to be determining the hours. So different than we ever had. So we as the attorney need to get in there, and we need to proactively make sure that our clients get hours. Now, on top of all of this, we now have even an extra review if a client needs high hours, and they're saying likely 12 hours or more. There's going to be an extra review to see if the individual is safe at home. Well, really, what are they trying to do? Kick the individual off Medicaid, in my opinion. That's what we're doing. I think it's sad, it's sick, and it's awful. But that's what's happening. We have to proactively get involved. The CDPAP program, consumer-directed program, is there, but it's also under fire. Make sure that you use the Medicaid Asset Protection Trust when you protect the home, unless you're making exempt transfers. So if we're doing planning, individual comes to me, age 65, 70, 75, 60, 80, and they're in great health, and they just want to do long-term care planning. We want to protect the home. We want to protect assets. We'll transfer those assets into the trust. But if a client needs to go on Medicaid soon, and there's a disabled child, we won't use a trust. So we might transfer that home to the child subject to a life estate, but typically the life estate transfer won't be a good idea. So many of my clients want to, even though they say they won't, want to sell that home at some point, and you can't do that. We don't have time for it, but look at all of the advantages to that Medicaid Asset Protection Trust. And look at the disadvantages, almost nil. So you want to do it. The only reason you may want to not do the Medicaid trust is if you're there at the last minute and you have an exempt transfer. All of the good reasons to transfer assets into that trust. You do get a basis step up upon death. You do, if the trust is drafted right, you do get the $250,000 or IRS code 121A capital gains tax exclusion for $250,000, $500,000 for husband and wife. Here we talk about transfers subject to a life estate. Don't forget about the right of election. Medicaid says that you cannot waive the right of election, but the IRS says you can. So if there's a prenup or a postnup, usually waive the right of election. Medicaid will not listen to it, and they won't abide by it. Be aware that there's Medicaid recovery. So although we might do all this great planning, Medicaid going in and getting eligibility, later on upon death, Medicaid could recover against the assets. So we have to do planning for that as well to avoid recovery. Because of COVID-19, we have some regulations that are there but eased up, with regard to recertifications for Medicaid and certain other programs which you see there. We submit our Medicaid applications e-fax-wise. We can have the client attest to income and assets, but we're going to have to prove them later on anyway, so we're gearing up for that. And we submit anyway to Medicaid on an expedited way. So we're lucky enough to do that. And we are having fair hearing decisions, which are done even now by telephone. Make sure that the financial advisor is a fiduciary and works with the attorney to make sure that the plan is done right. Again, with that irrevocable trust, no principal could be paid directly to the grantor. you want to make sure that you don't do that. The financial advisor will know how to do everything if they're aware of this. So make sure you have a good financial advisor. Again, my son and I have a company, but anybody that really knows the deal is good. Here you have these executive orders, and that's my presentation. 1 minute late. Not too bad, Diana.
Ron, we have some questions.
Sure.
Before we start the questions, I just want to mention one thing in case people need to hop out. I will resend this attorney affirmation along with the materials to everyone. The code word is Medicaid, no E, but if you put an E, you will still get credit. I know people had questions about the spelling, and it is a web conference. So that's all you need to know for the affirmation, and if you have any issues with it, just reach out to me, and I'm going to give it over to Jackie so she can give you some of the Q&As that we had. And I want to say thank you to everyone for attending.
Diana, how long can I stay on and do these questions?
You can stay on as long as you want.
Oh, okay.
And we're happy to have you.
Yeah, so I'll stay on for, a good 10, 15 minutes if people want.
Sure.
For those of you who are leaving, thank you so much for your time. I really appreciate what Judicial Title did. Thank you so much, Diana. I really appreciate it. What a great organization. And thank you guys for watching and listening.
Thank you, Diana. So, Ron, first question from Judith Rawcliffe. In Connecticut, the statutory healthcare proxy allows the appointment of a conservator guardian of the person without the necessity of a court proceeding. I've been adding such language in my New York healthcare proxies. Is this enforceable in New York?
I don't believe so. I think you're going to have to go in for a proceeding, but it's actually quite good to have language somewhere. Some people put it in a will as to who they want to name as a guardian if they should become incapacitated. Let's say there's no spouse, you have 3 children. The preference is usually abided by the judge. But I don't think it's going to stop you from needing a guardian and going, through the proceeding.
Andrea Maldonado asks, if you re-notarize an original document within the 30-day period following, are you still putting the date as the date it was virtually signed and notarized?
Yes, the executive order does say the as of date. So that's what we've been doing, yes. And you're welcome.
And do these documents have to be sent to the notary the same day signed, or is there a time frame?
So they have to go back to the notary and back to the witnesses same day. But it doesn't have to, no, you don't have to do that the same day. Just the individual is notarizing has to get it the same day, electronically or in person, and the same thing with the witnesses. That has to be done the same day.
Harry Friedberg asked, do the witnesses to a will have to be in the same physical place as the signer? No.
You could have one person in, Great Neck, one person in Muncie, and one person in, no, they could be anywhere.
Okay. Judith Rawcliffe, spousal liability for Medicaid in Connecticut has a filial responsibility law. So even the kids are liable. New York doesn't.
Wow. Okay. I did not know that. I know Pennsylvania has filial responsibility. I didn't know that. Fascinating and awful. Maybe unconstitutional. I don't know. But okay. Thanks for the information, Judith.
Yeah. Eve Vital requests for an answer to, are co-ops considered a home for Medicaid purposes?
They are, actually. They are. So New York State does consider, a co-op that you live in as your primary residence, a so-called homestead for Medicaid. Yes. So you should be all set.
Does divorce, this is from Gary Ring, does divorce terminate spousal responsibility?
I would say yes in most cases. If you divorce somebody and leave them on Medicaid as a public charge, so in other words, if you're divorcing someone and they're a quote unquote a public charge or maybe on Medicaid, that could be an issue. But if there's a divorce now and there's a Medicaid application a couple of years down the road, I don't see how that's going to be a problem. I would say the spouse is not a spouse any longer.
Okay. James Reduto asks, is a disclaimer EPTL 2-1.11 of a gift under a will considered a transfer for purposes of the look-back rule?
I have a long answer for that. I'm being facetious. Yes, it is. It is a transfer.
Okay. He also asks, can the trustee of an irrevocable Medicaid trust pay the funeral expenses after the death of the grantor or beneficiary?
Okay, you know what? No. But most of these trusts do provide that assets could be paid out to the beneficiaries upon death, and they'll just pay the funeral home. And funeral homes know the deal. I mean, usually they'll wait, but if they don't, you could make a distribution. Obviously, you want to do it right and do the trust administration and, to protect the trustee, the fiduciary, and have at least an informal accounting and receipts, releases, and refunding agreements. But the answer is no, can't go directly back, but it could go, let's say, to the kids or whoever the beneficiaries are to pay at least enough to pay for the funeral costs.
And this is the last written question. Angelita De Silva, is it possible to have several signature lines so that a will can be signed at different times before separate witnesses and notary?
Sure. I don't see why that's a problem. I think a cleaner way to do it would be to get that document back as the notary/witnesses, notarize it and witness it, send that back to the individual who had it. So that would be a complete document. And then they just have to mail it, the original, to you. And you could then, I'd say within 30 days, I don't know why they use the word may, just notarize, witness it. We use the individuals in our office, and I'm hoping and praying we're going to be back within the 30 days. I hope, because I'm getting cabin fever here, and I'm sure you guys are as well. Any other questions?
That's all the questions.
All right. Well, guys, I just want to thank you so much. I really had a good time, and I want to thank Judicial Title again, Diana and the whole crew at Judicial. Thank you so much, and hope you learned something. Looking forward to do it again, and I appreciate this so very much. Take care. Be well, stay safe. Thank you.